That was the takeaway.
Good afternoon. And before I make any comments, I want to preface them by specifically referring to the ethical rule that allows me to provide the information I'm going to provide and to direct your attention to specific pleadings and or filings that have already been made in the case of State v. Milke. Specifically, Arizona's ethical rule 3.6c provides that a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effects of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. As my client is the state in this case, and the people of Arizona, continuing mischaracterizations and reliance by the defense on statements of the Ninth Circuit's opinion to mischaracterize the state's witness and to make derogatory statements are misplaced and disingenuous. Secondly, efforts by the defense to insinuate criminal conduct by the state's witness are perverse efforts to intimidate the witness and to try to keep him from testifying. And lastly, there is no basis for the state's witness to need to assert the Fifth Amendment, as there is no conduct that could be prosecuted in the first instance. And secondly, as set forth by a letter from the U.S. Attorney's Office for the District of Arizona, even if there had been, statute of limitations have run their course. Now, in particular for the conclusions drawn by the Ninth Circuit, and I previously alluded to how they were factually incorrect, we're going to provide you with case summaries for the cases relied upon by the Ninth Circuit to insinuate and or outright assert misconduct by the detective in question. First, in the matter of State v. Yanez, CR 130403, the Ninth Circuit, in their opinion, characterized that case as a Fifth Amendment violation. However, the Ninth Circuit, in criticizing Detective Saldate because he admitted interrogating a suspect who was strapped to a hospital bed, incoherent after apparently suffering a skull fracture, quote unquote, is unsupported in the record, nor did the trial court or defense allege misconduct by the detective. To the contrary, in the defendant's own pleading, the defendant had acknowledged that Detective Saldate had no knowledge of the extent of the defendant's injuries when he was questioned. And yet that's the very conclusion that the Ninth Circuit draws. Unsupported by the record, unfair, mischaracterizing, and false. There's absolutely no evidence in the record that at the time the defendant in that case had been questioned that the detective knew what the medical condition was. And no way for him to have known that there were any skull fractures because the initial medical records, the initial x-rays, were negative for a skull fracture. This is the first of what I'm going to do several times now, pointing to specific facts in a record that the Ninth Circuit had an obligation to review and was irresponsible and incorrect, and that has now been repeated by the defense time and time again. The next case has to deal with State v. Rodriguez, CR 161282. And in this particular case, the Court of Appeals tried to assert that the detective had, quote-unquote, lied under oath before a grand jury. However, the determination by the trial court to remand the case for a redetermination of probable cause had to do with the court's assertion that, well, the court reporter's transcript and notes seemed to indicate that the detective had testified to, in this case, 4 shots having been fired when there was only 1. Now, trial courts, when faced with something like that, because going back to a grand jury for a redetermination of probable cause does not present inordinate problems for the state in order to be able to continue a prosecution, will, all things being equal, ask for a redetermination. But there was no finding that there had been any false statement by the detective. It's a conclusion drawn by the Ninth Circuit and also drawn without reviewing the entirety of the transcript for those grand jury proceedings. Had they done so, they would have seen several different instances where both the prosecutor and the detective repeatedly referenced that there was only a shot. Specifically, that during the grand jury presentation, there was an indication that the cause of death was the shotgun blast to the back. Testimony that the victim's friend heard a loud shot before seeing the victim slump over the bike, and testimony that nearby witnesses heard a shot, and then testimony that there was a spent shell casing found at the scene. But in a rush to draw a conclusion that would support the Ninth Circuit's apparent desire to take out the detective, they glossed over all of that. Next, State v. Condi, CR 88-05881, parentheses B. In this case, the Ninth Circuit Court of Appeals characterized it as a Fifth Amendment violation, completely misrepresenting the ruling in the case as it related to the conduct of the detective. The statement in question was one where the court ultimately found the statement involuntary because the defendant had not been given his initial appearance within Rule 4 guidelines due to the defendant's hospitalization. The statements were not admissible because the defendant had not been given his initial appearance in the proper amount of time. What the Ninth Circuit tried to say, though, was that the defendant had been interviewed despite the fact that he had a medical condition, was drifting in and out of consciousness. In the first interview that the detective had with the defendant in this case, and again this is State v. Condi, Condi was read his Miranda warnings. He made some admissions about participating in the crime as he drifted in and out of consciousness, and because of that condition, the detective stopped the interview as documented in the police report. 10 days later, the detective went back and spoke to the defendant and interviewed him. But again, the Ninth Circuit in that case focused on the first interview that was never submitted by the state in the prosecution. And the only reason there were issues with the statements was because of timing issues for the initial appearance. So, yet another case where the Court of Appeals completely misrepresented a trial court's rulings. State v. Reynolds, CR 880605. In this particular case, the detective testified that a witness to a homicide, a 5-year-old boy of his mother's homicide, the detective had summarized that the boy had seen his mother upstairs being drugged by the perpetrator late at night. The interview of the 5-year-old that the detective had reviewed as part of his whole investigation goes as this. A question of the 5-year-old. When did you go to bed last night? 8 o'clock. Were you watching anything on TV when you went to bed? Gary Shandling show. You went to bed after that show. Yeah, this man came in and turned the TV off. Did he say anything when he left? No. All he did was turn out the lights and turn off the show. Question. I thought he did that when he came in. Answer. No, when he left. Question. When he took your mom upstairs, where were you? Answer. In the living room. Question. The whole time? Answer. Yeah. Question. Did you get to watch all of Gary Shandling? Answer. No, he turned it off. I only saw the first part. All right. Now, again, if the Ninth Circuit had been doing its job, they would have been able to figure out, with the clerks that they have, that the Gary Shandling show aired on Sunday evenings at that time in 1988. And the date of the crime, September 6, 1988, was a Tuesday. Therefore, the statements made by the 5-year-old couldn't be relied upon to try to establish a time frame. Instead, the detective in that case, having interviewed a friend of the victim, had learned that the victim's friend was at the victim's apartment between midnight and 12:30 a.m. Therefore, the reasonable inference is that if the 5-year-old boy had in fact seen his mom go upstairs with the suspect, something reasonably you could deduce from that, but not trying to give credit to a time frame statement because there's no way it could have been right. Could easily have said, as he did before the grand jury, that the boy saw his mom go upstairs late at night without providing a specific time. Now, while the court ordered a new grand jury determination, there was no finding of misconduct. Again, the Ninth Circuit, on a wild goose chase, went after Detective Saldate and misrepresented the record. With respect to intoxication and the suspect's memory in that case, there were 2 interviews that the detective had of the suspect. Towards the end of the first interview, the suspect told the detective that he may have gone back to the victim's apartment on the night of the murder, but he was too drunk to remember because he was drinking and smoking marijuana earlier in the day. Could not remember whether he went back on the night of the murder. During a subsequent interview, the suspect told the detective that although he was drinking at a barbecue and continued drinking at a pool, he did not believe he was drunk. During the grand jury presentation, a juror asked a question about whether Reynolds was intoxicated. The detective replied that during an interview with me, he said he was not drunk. He had been drinking but was not drunk. That's exactly accurate in that second interview. But in the opinion, the Ninth Circuit classified that case as one where Detective Saldate had lied under oath. The court characterized the detective's testimony about intoxication as a false statement. Yet I've just cited to you exactly what was said. Now, the other part here is that in the record itself that went up to the Ninth Circuit, it's Exhibit 15M. It contains a minute entry from the judge remanding the case to the grand jury, and that order involved a grand jury presentation in October of 1988. But the transcript of that proceeding was not a part of the record. So how the Ninth Circuit could have drawn that conclusion is completely unbelievable. Now, State v. Rangel, CR 89-08086. And again, for everybody, if you don't have a copy of these cases, we will have a copy for you, but I'm drawing attention to you, your attention to specific points here. Now, in this particular case, the Ninth Circuit again classified it as one of lying under oath, and the court alleged that during the grand jury testimony, the detective omitted some of the defendant's statements in such a way as to make the defendant look more culpable. That's not accurate. During the interview, at one point, the suspect stated, "I think I may need an attorney." An equivocal invocation at best, but nonetheless a statement that he might need an attorney. At that point, the detective documented the request and told him that was his decision, but that there were further points that needed clarification. Eventually, the suspect admitted that he had a weapon, which spurred an argument between he and the victim, and it ultimately resulted in the shooting when the victim got out of the truck. Those are inculpatory statements. They're not exculpatory. They don't lessen someone's guilt. During that presentation, the attorney for the state decided to only present the suspect's version of events on the night of the murder that preceded the request for an attorney. A perfectly reasonable decision, because even though it may be an equivocal invocation, sometimes prosecutors will just decide, you know what, I don't even want to go there. If we can secure the probable cause finding without needing that, we can argue that issue later and avoid a remand situation. Well, that's what happened here, though. A grand juror asked this question about whether or not did you confront him, and goes through the series of items that the suspect had provided involving the sequence of events, and concluded with a question of, did you ask him why she didn't take her boots with her to drive the car again? But before the detective could answer, the prosecutor said that that point again, we can't, for legal reasons, can't get into that. Trying to protect statements after a point where a suspect had spoken about an attorney. So they didn't hear that because of the prosecutor's decision, not because of the detective. Therefore, the Ninth Circuit's assertion that that was lying under oath and omitted some of the defendant's statements in such a way as to make the defendant look more culpable is patently false. State v. Mailer, CR 90-00296. In this particular case, the Ninth Circuit opinion failed to mention that the trial court found the confession in the case to have been lawfully obtained, and instead characterized it as a Fifth Amendment violation. This is yet another example of failing to acknowledge that the detective had fully documented everything within his report, and but for that honesty, no one would have been aware of the circumstances surrounding the statement that was taken, and that the trial court had found that it was admissible. Now, the Arizona Court of Appeals decided otherwise, but the fact that the record is what the record is what the Ninth Circuit should have relied upon, instead of, again, more grandiose characterizations. Next, State v. Jones. And I will note for you that in State v. Jones, the defendant's attorney is the person currently representing Detective Saldate. In that particular case, the Ninth Circuit characterized it as a Fifth Amendment violation The court claimed that the trial court, in suppressing the defendant's confession, had found that the detective had behaved improperly. The scenario is this. While at the police station, and during the course of an interview that Detective Saldate was conducting, he stepped outside of that room to tell other officers about the information he had received up until that point. And this is all documented in the police report. At that point, he saw the defendant, Jones, and other individuals in the lobby, and he suggested that they all be separated so that, presumably in case they were somehow involved in the victim's disappearance, their statements would not be coordinated or rehearsed. Now, unfortunately, at that point, another officer, a different officer, placed Jones, the defendant, in an interview room and handcuffed him to a table. At this time, while Jones had come to the police department voluntarily, there was no probable cause to have arrested him. Eventually, a different detective came into the room, uncuffed him, and then began to interview him. And then during that interview, the defendant confessed to participating in the victim's murder. However, the claim that Detective Saldate had directed an officer to place a juvenile by himself in an interrogation room where he was handcuffed to a table is false. The trial court made no such finding. In fact, the trial court said, at the direction of Detective Saldate, he, the suspect, defendant Jones, was separated from his two companions and placed in a police interview room, period. He was handcuffed to a table in that room, period. It's a sequential statement of facts about what happened. It is not an assignment of responsibility for misconduct. In fact, yet again, it's noteworthy that in that particular instance, the defense counsel for Jones, his current attorney for Detective Saldate, said to the judge, and when I say misconduct, I don't mean bad faith misconduct. There was never an argument that Detective Saldate had behaved inappropriately or improperly. There was no time where he had ordered that the suspect be locked in a room or handcuffed to a table as set forth by the Ninth Circuit. That's just shameful for a court that is supposed to be paying attention to a record. Next, State v. King, CR 90-00050. In this instance, there's yet again another mischaracterization by the Ninth Circuit that Detective Saldate had lied under oath and engaged in a Fifth Amendment violation. In that particular instance, as fully set forth in the police report drafted by Detective Saldate, a portion of the interview goes as follows between he and the suspect, later defendant King. Question. When the detective attempted to focus King on discussing the murders, King stated, quote, "Look, I know the game. I know exactly what you're trying to do, but I'm not going to answer any more of your questions," close quote. The suspect went on to say that he knew how the system worked and that he had no reason to commit the murders. He continued to laugh at the situation and made jokes about Arizona's failure to actually use the death penalty, stating that it would probably be used against him if he was convicted. Now, during the voluntariness hearing, the following exchange occurred regarding the suspect's willingness to discuss the murders. Question of Detective Saldate: did he ever specifically say he didn't want to talk to you about it? No. Did he ever say he didn't want to answer any questions? No. That is exactly true. What should have been asked next, though, to support, well, to flesh that out, would have been, at what point did the suspect say he did not want to talk about the murders anymore? Saldate told the trial court, and it was noted in the supplement, that the defendant denied his involvement in the murders. Now, on cross-examination at that point, the defense counsel asked the following questions. Question: now you told us on direct examination that he never said he didn't want to answer any more questions. Is that right? Answer: correct. Question: now in your report, let me read from your report. Look, I know the game. I know exactly what you're trying to do, but I'm not going to answer any more of your questions. Is that what he said? Yes. It's not lying, and it wasn't a Fifth Amendment violation. Nowhere in that hearing did the defense attorney allege that the detective had testified falsely, and nowhere did the trial court even remotely make such a finding. Now, I spent all that time on those in order to draw your attention to it, because that has served as a basis, as I said, for continuing mischaracterizations by the defense in public to the media. And it needs to stop, because it amounts to an effort to try to intimidate and mischaracterize the state's witness to convince him not to want to testify because of all the negative publicity. It's false. In fact, even if you go to, and I'm going to direct your attention to the district court's findings and order after the evidentiary hearing there, and now we're going to talk about specifically statements that were taken by Detective Saldate in the Milke investigation. Yet one other court that had the opportunity to weigh the statements made by Detective Saldate and the defendant found him more credible and found that the statements made by both of them largely converged. In particular, the statement with respect to whether or not the suspect at that time, now the defendant, had wanted her confession/statements to be recorded. And even at that evidentiary hearing, the district court noted that Detective Saldate had asked if she wanted the interrogation to be recorded, and she did not want it recorded. So continuing characterizations that somehow it was solely Detective Saldate's doing that the interview was not recorded are false. And they're also reflected in the original trial transcripts. In a couple of press conferences ago, I even provided media that were here the specific transcript date, the page numbers, and the line numbers at which that fact is corroborated between Detective Saldate's testimony in the voluntariness hearing and then Milke's subsequent testimony at trial that corroborates that she did not want the interview recorded. And specifically during her testimony, and the date of the transcript is October 3rd, 1990. The page number is 17, and the line numbers are 22, 23, and 24. I will tell you that in that part 2, she does say that she wanted a lawyer, and that was a point of dispute. But there are many other aspects to that interview, both at the time of the original trial and then in the district court, where what was said during that time are corroborated by the defendant from what Detective Saldate put in his report. And again, for comparison's sake, during the voluntariness hearing, that transcript at page 52, lines 15 through 17, again, to clarify, the question by the defendant's attorney in that hearing, you chose not to record it, isn't that true, sir? Answer, she said she didn't want it recorded. So we can quit mischaracterizing that as well. Now, the last point to make has to deal with whether or not there really is a basis to be concerned about any Fifth Amendment issues. And I have, and I think we've provided a letter from the United States Attorney for the District of Arizona clearly stating that the office would decline to pursue charges for the referred conduct from the Ninth Circuit, in which they wanted just about anybody and everybody in Arizona to be investigated for what happened at that time. But specifically, the declination is based on the federal statutes of limitations governing the applicable statutes under the United States Code. There is nothing that Detective Saldate could be charged with. And truthful testimony in any future proceeding would be just that. And anything consistent with what he testified to at the evidentiary hearing in the district court or at the trial court could certainly not be fairly characterized by anyone at the Ninth Circuit or at any prosecutorial office as having been false or permitting any subsequent criminal charge. Any other allegations of criminal conduct dating from even in the last couple of years has resulted in no credible evidence that could be submitted to any prosecution agency. Now, I hope you can appreciate how unusual this is, because I normally won't speak about cases while they're currently going through active prosecution. But I felt consistent with the provision in the ethical rule that permits rebutting false information, particularly if necessary, in order to avoid prejudice to the lawyer's client, in this case to the state, and our ability to have a fair trial. I felt it important. I think it's also important for Christopher Milke, 4 years old when he was killed, and 4 years old to this day, and he'll never be more than 4 years old. He deserves justice and due process too, under our Victims' Bill of Rights. And I won't stand by and watch the defense dance on his grave anymore. That's all I have to say. I'll take your questions, but please understand it has to be narrowly limited to the information I got.
If this opinion is so flawed, Bill, why didn't you request an in-bank hearing or appeal it beyond the Ninth Circuit?
I do not have jurisdiction to do either of those.
Mr. Montgomery, everything you said is very clear. I look at this letter here from the U.S. Attorney's Office dated August 30th. I gotta assume that Detective Saldati and his attorney were aware of the federal government's decision not to pursue criminal charges against him before they appeared in court yesterday, announcing their intention for him to assert his Fifth Amendment rights. Given that, I mean, now you're saying obviously he faces no charges from the state, or no matter what he testifies to, if he testified truthfully. I got to assume he was aware of that yesterday. Do you now have yourself a hostile witness? How do you force him to testify? I guess it's going to be up to the judge whether he can plead the Fifth, but now you've got a witness who doesn't want to testify.
Well, and I share in your consternation, and you're accurate in saying that it's not going to require a proceeding or certainly maybe action by the judge. And that's the forum, well, where we'll have to make any further argument.
But it very well could come down to, the judge forcing Detective Saldati to take the witness stand.
And I want to be very careful about trying to predict what might happen in that regard. I really want to limit my comments to what I just said here, being overly conscientious about what I'm supposed to do and not do. Yes?
The press release says that they're barred because of applicable federal limitations period. That's
Correct.
why they can't prosecute him.
Yes.
His defense attorney has said that he wants complete immunity for Saldati. Can your office give him complete and total immunity prosecution for perjury and civil rights violations?
There is no basis for me to offer immunity. There's simply no basis.
So are you telling us you're going to go forward with this case and pursue the first-degree murder charges against Debra?
Oh, at this point, we're definitely proceeding. Oh, absolutely.
And what about Belinda Reynolds? In 2010, she came forward with allegations of extortion for sex when Mr. Saldati was a constable.
And what I said earlier is that there is no credible evidence to support any allegations of recent misconduct either.
Mr. Montgomery, go ahead.
If Saldati refuses to testify, how can you prosecute the case any further?
There may be several options at that point, but I don't want to get ahead of myself and start assuming the worst then when there are still several steps in between where this has every opportunity to go forward as it should.
Is this news conference really an attempt to convince Mr. Saldati to withdraw his Fifth Amendment action and go ahead and testify on his own volition?
Fair question, but no. Given recent statements this week by defense counsel for the defendant, it finally got to a point where I can't let it go unanswered anymore. The mischaracterizations of why the state is seeking to pursue this case or of witnesses essential for the state's case simply got to a point where I finally felt comfortable enough with what the ethical rule allows me to say to then hold this press conference and present this information.
As I recall, earlier this week, from your mouth and in court once a few weeks ago for Mr. Imbordino, it was said that if Detective Saldati doesn't testify, they can bring up his previous testimony. Is that accurate?
Yes, that is a possibility. Generally speaking, under our rules of evidence, if a witness is unavailable, you can use prior sworn testimony.
But it was my understanding yesterday the judge basically said that if Saldati doesn't testify, the confession's out. So his testimony was all about the confession, right?
Well,
Am I misunderstanding?
in large part, however, what I would say is that that colloquy with the court at that point in time didn't necessarily concern what happens if the witness is unavailable and what other options the state might have. To the bottom line point that in order for a judge to make a determination in that there would have to be testimony from whoever took the statements from the defendant, that's an accurate legal statement.
Mr. Montgomery, how important is Saldati's testimony to this case moving forward?
It's another piece of evidence, and given the nature of the case and the gravity of it, we want to be able to use all the evidence that we can. What's more concerning or disconcerting for me at this point is that characterizations of the witness have driven him to a point where his attorney has said what he said in court. And those characterizations are false, and therefore the information that I'm providing today is an effort to clarify that record and make sure that accurate information is out there and again, stop the dissembling from the defense.
So as a follow-up to that, you believe if he doesn't testify, you can still make the case?
As I've said before, though, Ted, once we get to points where particular determinations are made and evidentiary rulings are made by the court, every single time one of those rulings are made, prosecutors take a new look at the case. The case could get stronger, the case could get weaker. If evidence is tossed, it's always then a position for the state to try to determine whether or not, based on remaining evidence, can we still make our case, or is there another way that we might be able to use the evidence that, based upon the court's ruling, at least preliminarily, we wouldn't be able to use.
Surely you've thought of that. What's the answer? Can you do it without the confession?
I don't think I want to tell the defense at this point how I want to go forward.
This handout outlines all of the cases in the Ninth Circuit Court of Appeals opinion here, but you failed to address Saldati's personnel record that the Maricopa County Attorney's Office failed to provide to the defense long ago. It was clear in 1973 he had serious issues of misconduct that were swept under the rug to the defense.
And
his integrity was compromised. He extorted a female motorist for sex in 1973. He drove to the location, the woman didn't, and she called police and reported. He was suspended for 5 days, but this doesn't address any of his misconduct and why the county attorney's office failed to disclose this to the defense.
okay, and those assertions too by the Ninth Circuit regarding the level of responsibility for disclosing records, if you go through and look at it, they cite a couple of cases that occurred in 2000s and beyond, well after the original court date. And at the time of the case itself, it is absolutely not clear that this office had that information and failed to provide it. Now, that being said, because of the fact that when the state goes to trial, the state is looked at as everybody, the prosecutor's office and the police. In that particular instance, there was a subpoena from the Phoenix Police Department for information. The court reviewed it and denied some of the defense's requests for information. Whether or not that specifically included that incident, which was about 14 years before this homicide occurred, even on the basis of those 14 years, under Arizona rules of evidence, you wouldn't be able to bring it in. So the fact that it wasn't used in that original trial really isn't dispositive. Now, the Ninth Circuit threw that in on top because, well, it makes for a nice additional accusation to make. But as for whether or not there was any concerted effort to prevent the defense from knowing about that, I don't believe that happened. And there's no record to support it either. It's another over-the-top conclusion.
And speaking of that, what you're referring to, Judge Rose Moraz has indicated and made it abundantly clear that the opinion from the Ninth Circuit Court of Appeals is the law of the case. You were chastised during some of the hearings about speaking out against the Ninth Circuit Court's opinion, and yet you continue to do that. How would you respond to that?
Well, and we will be responding in a motion to the court, setting forth a lot of the information that was shared here. Because the law of the case point, well, I understand what the court said there. There's additional information that's going to be presented in order to argue differently. And we'll make that argument there. But as I've gone through now and pointed out everything, look, I have an obligation as an officer of the court and as the elected county attorney here to also do exactly what I just did, which was to clarify mischaracterizations that are negatively affecting the state's ability to have a fair trial. I'm not criticizing our court here, but that information that I believe I've just provided, look, there are specific cites, the facts, transcripts, and in the record, and it was an abysmal ruling by the Ninth Circuit.
Now, Mr. Montgomery, though, given your contention of mischaracterization and the Ninth Circuit's ruling based on flawed reasoning and flawed facts,
Well, not so much the reasoning, but the flawed facts
sure,
itself.
I understand that. But, I guess the fact of the matter remains that it was a ruling, and her conviction was overturned since as well, and it remains part of the record. Does that not give you an uphill battle now, despite its...
Well, without that ruling, I wouldn't be here today.
Sure, but now you have to face that ruling
Right.
throughout, right? I mean, it
Well,
remains weak.
so I just mentioned we're filing a pleading with the court in order to present a lot of this information to the judge there. And again, the arguments to be made about that with our trial court will be made there.
Can I ask one more thing?
Sure.
The Ninth Circuit Court said that Saldati's testimony in the Milke case was a lie. Can you reasonably expect a trial judge to allow that testimony in the retrial? And is it because Saldate knows he lied?
Well, And again, though, Wendy, I think from what I just went through, for the Ninth Circuit to come to that conclusion based off of other wrong facts that they had, that conclusion is equally wrong. You know, we had the evidentiary hearing of the district court, which the district court, in weighing everything, found Detective Saldate's testimony credible. And it just about, I think the quote from the district court, as a matter of fact, regarding what was heard at the evidentiary hearing with respect to the trial. Now, this is at page 8 of the findings in order. The evidentiary hearing testimony of petitioner, the defendant, and Saldate mirrors the testimony they provided in state court. And then at the end of that paragraph, the last two sentences, while the versions conflict at several key points, at many other points they converge. So, courts that are finders of fact and have actually sat to review the testimony and hear from people did not find that. That's a danger when an appellate court tries to become an original fact finder.
Isn't it a rather novel legal theory to try to get Judge Morales to discount the rulings of the Federal Appeals Court in the Ninth Circuit?
No less novel than what the Ninth Circuit did.
Are you really doing this today because Judge Kaczynski wrote that your office should be ashamed of itself for its conduct in this case, in these decisions? How sharply worded it was?
Well, no, and again, the judge there should have kept in mind that with the 20-plus years that has passed since then, the office today is not the office that it was then.
Do you believe
That's about as pointed as I'll get with him.
Do you believe that Mr. Saldate is an honest man?
I believe he gave honest testimony, and that's just not my conclusion. It's a conclusion of a trial court at the state level, and it's a conclusion of a district court at the federal level.
Ms. Montgomery, I mean, this is all sort of obvious here. It kind of feels like this whole case has spiraled into a retrial not of Ms. Milke over the death of the child, but a retrial of Saldate's credibility here. I mean, did that just cloud everything? Here we are talking about Saldate over and over again. Your case is clearly about Debra Milke and justice for the child.
Right. And that then, again, I think you just gave another way of illustrating the importance of trying to clarify the information as ER 3.6 permits.
So moving forward from here, without Saldate's testimony, will there be a retrial? Can you give us a definite answer?
Oh, well, no, because I don't want to, at this point, try to say yes or no, because when we get to a point in the case and in the prosecution, other things may have come up that could buttress the state's case to the point where we could get by without it, or we get to that point and a different determination has to be made. I don't want to tie my hands right now. One of the things that I try to get across to our prosecutors is that when you're handling a case, you have to keep a wide enough view so that as there are changes and developments, either evidentiary-wise or procedurally, that you don't tie yourself to only one possible course of action. If at the end of the day what we're trying to do in each and every case is achieve justice, well, then that measure of justice might have to be reviewed given the kind of case that we have to present. So I can't give you an answer right now, yes or no, because there's still a whole lot of other stuff that we need to do, and
so
procedurally in court.
to clarify, the motion that you're filing is going to ask Judge Morales to reconsider the facts that the Ninth Circuit used to form its opinion?
I'll just characterize it this way, because I don't want to make the arguments that are in the motion here. That's for the court. We're providing a lot of that information that I've shared with you here today that includes where we point out errors in the Ninth Circuit's conclusions. And you're right, earlier, I mean, to Steve's point too, it is very unusual. I was dumbfounded when I read the opinion and in researching what had actually happened in those cases, that the reality was very different from how they were characterized and the conclusions that were drawn. And I can't explain why. I really can't. But at the same time, where the state has the obligation to present evidence and argue its case and prosecute a matter in a state court, I can't ignore if there are factual inaccuracies and I have different evidence and information that I can present to a court. I should believe that as an officer of the court in front of our judge, we have an obligation to let the court know that, hey, what you may be relying on is not accurate. And that's not to get into a back and forth with the judge. That's simply doing what, whether it's a prosecutor or, in point of fact, a defense attorney, and trying to help the court get things right too.
And who are you providing that information to?
Oh, the judge in this case.
Well, just because you say that the Ninth Circuit Court ruling is wrong doesn't make it wrong.
No.
How can you fight a federal appeals ruling in state court?
How can I do what?
How can you fight a federal court opinion ruling in state court?
Well, the way that we're going to do it. We're going to provide the information. And, you know, the basic principle or theory of the law of the case is that on the basis of a particular ruling where you have the same facts in basically the same matter, well, then that law holds. But if in reality you have different facts, well, then you call into question whether or not that principle truly applies.
Well, suppose you're successful and the judge accepts your argument and considers the case, it goes up on appeal back to the Ninth Circuit. Under what scenario would they not toss it out again?
Oh, I don't think it necessarily would result in, you know, we're not looking to appeal the case back to the Ninth Circuit.
No, but the defense would be.
Oh, maybe they might, maybe they won't, I don't know. But the difference would be that this time around, hopefully we would have a record that the Ninth Circuit would actually read and then come to appropriate conclusions.
At the end of the day, and just follow up on his question earlier, at the end of the day, the lawyer for Mr. Saldati went into court yesterday and said that he's going to plead the fifth. Again, is this your effort to send up the signs that you want that to change, and he will not be prosecuted at your level, and obviously not at the federal level according to that letter, but he's free and clear and he should change his mind and come in and testify?
Yeah, Mike, I didn't need to do this for him to be aware of that, and he should be aware of that.
Is
In
Mr.
fact,
Debus, are you communicating with Mr. Debus, and does he indicate that Mr. Saldati would be receptive if the air is cleared, you guys can make make it clear to the judge and the public and everything else that this guy's a credible guy and none of this is true about him and he should come in? I mean, ultimately, that's what I think you want.
well, what I want is to be able to present a full case to a jury and then leave a decision up to them as to guilty or not guilty, and have a fair opportunity to do so. But I have not been in direct contact with Mr. Saldate's attorney. I know that he's had a copy of this letter. I know he's aware of what our position is, and you know, as to additional determinations or decisions that the court has to make with respect to whether or not there truly is grounds to even be able to assert the fifth in the first place. If need be, we will then follow that course of action. We'll take those steps. But you know, from everything that I've shared with you, there is no objective basis for Mr. Saldate to fear prosecution from anyone for anything.
He's been ducking all of us for 20 years. Why do you think that he's going to now go around and testify in court, having said he didn't want to do it?
Oh, because I got a nicer tie. You know, I think, again, when we have an opportunity to make our case within the court and to clarify a lot of these issues and get some orders and rulings on the record, I think that will help clear that up.
His attorney has indicated he will not voluntarily cooperate with your office. There is information that he feels he has been mistreated by the Phoenix Police Department and the Arizona Attorney General's office. If he takes the fifth and he refuses to cooperate with your office, today, you know, you're attempting to say that you believe he's being intimidated by the defense through the media.
Yes.
So his attorney has indicated he is not going to voluntarily cooperate with your office.
And that may be the most recent statement, but there are days to go.
Following up on that, I mean, let's say he does continue to maintain and assert his fifth, would your office seek to force him to testify?
I don't want to contemplate that at this point. I think there's a lot of stuff that could be done and addressed between now and then that would necessarily obviate the need to continue to assert the fifth. Again, not the least of which is the fact that there's no objective basis to fear prosecution.
So then what's his hang up?
I'd have to be his attorney to figure that out and to hear that from him.
Do either of the two men on death row are you working out any negotiation with Robert Steyer or Jim Steyer, anything at this point?
I have nothing to announce or to be able to comment on with respect to that. And if we were going to use either of those two, we would have to alert the court and the defense that they were going to be a witness for us.
Are you concerned that if Saldate does testify, that the defense will shred his credibility on the stand and impeach him? Is he a very impeachable witness in your opinion?
I would say that the degree to which the defense has shown no caution whatsoever in making a lot of outlandish statements, that they may not try to do the same thing in trial. But in trial, the judge is there to oversee the manner and mode of interrogation of witnesses. And of course, I would expect that the court would be able to, not just with the defense, but with prosecution, keep people in check. Any other questions? All right, thank you very much.
Thank you.